My name is Scott Walker and I am the Research Fellow at the Castan Centre for Human Rights Law. Before I begin, I want to acknowledge the traditional owners of the land on which we meet, the Woiwurrung, Wurundjeri and Boonwurrung people of the Kulin Nations, and pay my respects to their elders past and present. Our third panel today is on new challenges in climate litigation and human rights. As you might have heard in the last fortnight, it's been a pretty big week for this topic, with the handing down of the Australian climate case last week and the advisory opinion of the International Court of Justice this week. So it's particularly opportune that we have convened a panel with diverse experiences and perspectives on this issue. Let me say a few words about each of our panellists. Isabelle Reinecke is the Executive Director and founder of the Grata Fund. The Grata Fund is a leading non-profit based in the University of New South Wales that acts as a campaigner, litigation incubator and funder for peoples and communities challenging systemic gridlocks across three key areas: human rights, climate injustice and democratic freedoms. Prior to this, Isabelle has more than 10 years' experience as a director and lawyer at a number of organisations. Sister Brigid Arthur is a Brigidine sister and coordinator of the Brigidine Asylum Seekers Project. The Brigidine sisters have been engaged in education and social justice in Victoria since 1886. In 2001, Sister Brigid was a founding member of the Brigidine Asylum Seekers Project, which provides practical support for asylum seekers. Sister Brigid has also acted as a litigation guardian in a number of cases, including the Sharma case for a duty of care for the Minister for the Environment. And Professor Stephen Vaughan, who you met this morning, is Dean of the Faculty of Law at Monash University. Please welcome our panellists. Isabelle, I wanted to open up with you. The Grata Fund obviously was very key in driving the Australian climate case. Tell us a bit about that case and sort of your involvement in it.
Yes, thank you. And also paying my respects to traditional owners of this land, past and present, and any Aboriginal and Torres Strait Islander people in the audience today. I don't normally get nervous, but I see Julian Triggs in the audience, so feeling like I better do a good job. You're right, we have been really closely involved in this litigation that was brought by Uncle Pabai and Uncle Paul from the top Western Islands in the Torres Strait, Saibai and Boigu, against the Australian government. And our involvement in that case is sort of the fullest vision of what we do at Grata, which is work with communities really from the early days of addressing a systemic problem like climate impacts in the Torres Strait. And working with them, connecting them with a legal team or facilitating more legal support to address the systemic challenges that they face through the courts and then beyond the courts as well. And we do that through funding, so we facilitate philanthropic funding and other funding to communities and to their legal teams. We secure pro bono support. And then we work to co-design campaign strategies with the communities that are affected to make sure that the court outcome, whatever that may be, can be leveraged through a broader theory of change to really make sure that we get the impact that communities are seeking on the ground. And that's what we've done here. The Uncle's case, it's a negligence claim in common law. It's the first time that had been tried in Australia. And we were heartbroken by the decision. So you will know that the uncles were unsuccessful legally, although the judge accepted that basically every factual basis submitted was correct. So we've got a very good starting point for what comes next. But, it's bittersweet. There's been a lot of disappointment and tears and grief, and us chatting to my colleague Carly, who's in the audience earlier, that I think a moment like that, one case is not going to solve all of climate change and the problems that communities are facing, but the setbacks that you get in that moment, the disappointment you get in that moment almost like unpicks this other wound, which is this awareness of this global, as the court described it, existential threat to all of humanity that just kind of takes a moment to catch your breath again. But the factual findings were really, really strong, and I'm really hopeful because of those factual findings and the way that the judge discussed the law as it currently stands, that there's more to come.
Yeah, thank you. We'll come back to some of the what's next in a minute. Sister Brigid, I wanted to ask about your perspective that you bring to this panel. How did you get involved as a litigation guardian in the Sharma case, and what was that like?
Well, first of all, I think I got involved in being a litigation guardian, and it wasn't anything to do with the environment, but it's hard to get litigation guardians, I think. So having represented mainly, I suppose, asylum seekers in the court where the individual people didn't have the capacity to represent themselves, either they were minors or people with some kind of inability to represent themselves in court. So I did that for quite a number of asylum seeker people, but also with some young Indigenous, mainly young, a couple not, Indigenous people who for the same reason needed a litigation guardian. And then I think the firm that was searching around to see if they could take the case with the young people, 8 young people who wanted to take this case against the Environment Minister to court. Then they were searching around and probably Googled and probably came up with my name and approached me. So I think that's how I got into it.
And what was that process like, sort of day to day during the case? How did that sort of role function for you? And what was your motivation in doing that work, other than just need, I suppose? Yeah,
day to day, it was, I suppose, in one way, hands off, but in another way, because as a litigation guardian, you have to actually instruct the lawyers. So I couldn't afford to be, and they didn't let me, be too far removed from it. So we would have regular Zoom meetings and so on, mainly in that kind of medium, which is how everybody seems to meet these days. They were a great team of lawyers and the kids were amazing. So we'd sometimes have different subsets, sometimes the lawyers just meeting, but often the young people themselves who were really keen to be educated and who indeed were very savvy and knew a lot of stuff in any case. So it was, over the time, there was a fair bit of talking and, making decisions about what next and,
Thank you. Stephen, you bring a perspective on lawyers' ethics and a background sort of environmental regulation to this discussion. What are the sorts of ethical consideration that lawyers have in sort of bringing these types of cases?
Thank you. I started my life as an environmental lawyer, so I was in practice 10 years doing environmental law work. I did my PhD in chemicals regulation. If you're an environmental lawyer, you know that's the sexiest part of environmental law. And then a chance conversation with a legal ethicist got me interested in lawyers' ethics. And so for many years I was researching 50% environmental law, 50% lawyers' ethics. And then a paper came out by Natasha Affolter on the hidden persons in environmental law. And the point she was making is that we often focus on judges or policymakers, and there are other groups we might want to get interested in. And so I started looking at, initially, lawyers and large law firms, the sort of lawyer that I was, and their role in relation to climate change. So I acted for BP and BAE Systems, and the line was always, if it's legal, then it's fine. And I was like, I don't believe that. I don't believe that as a starting point. It's not sufficient for me as a premise. And so a lot of my work, what Isabelle said earlier, one of my first papers is called Existential Ethics. What does it mean to be a lawyer in those very large law firms where you know that the work you are doing has these very significant consequences? Is it okay? Is it sufficient just to say, I'm not a legislator, the law allows me? And then because I'm very equal opportunities, I've moved on now to critique in-house lawyers, NGO lawyers, movement lawyers, basically everybody. And the questions that I'm asking is, lawyers are products and agents and servants of the rule of law. What does that mean in relation to climate cases? What does it mean for your independence? What does it mean for your integrity? What does it mean for acting in a client's best interest, et cetera, et cetera? And all I ever want to do, well, two things. One, if I make lawyers feel a little bit uncomfortable, I'm quite pleased about that. And second, I want to encourage a conversation, because these things just aren't talked about as much as they should be.
Isabelle, you mentioned a moment ago about sort of next steps, and in the Australian climate case, Justice Wigney, as you said, made many findings of facts were in your favour, but mentioned sort of the unsuitability of the vehicle of negligence of this sort of case, and the fact that Australian law hasn't yet caught up to the justice needs. What is next?
Yes, it's an interesting one. So there are a few parts to this. On the one hand, I don't agree with Justice Wigney that the common law is not a suitable vehicle for dealing with an existential threat to all of humanity. But I understand the pressures that exist within our judicial system that led to him making that sort of a finding. And that's something I really want to draw attention to here. I think on the common law point, of course the common law evolves. What is Mabo? What happened before Mabo? Gove. Less known, stepping stone to Mabo. The uncle's case may not be the climate Mabo, but it has certainly created the stepping stones to it, and it's coming. The issue that is sort of and that's something that will keep coming through, potentially through an appeal, which they're very much looking at with their legal team at the moment, at Fifi and McDonald, and at the Victorian Bar, but also other cases as well, including, we got messages, in the days following the decision from lawyers all over the country basically saying, the factual findings in this are going to be really helpful for us in this one. Thank you very much. That's great. So we know that it's already shifting what's happening at a court level. But in terms of kind of the next big piece, that's still to be worked out. But I'm completely confident that that is a matter of time. The thing that I think is really important, particularly for this audience, that I would love to draw people's attention to is something that I think everybody here would agree with, which is that the court has a judicial lane which it needs to stick to. And in this judgment, Justice Wigney said, this would be beyond the judicial lane. This isn't justiciable. It's a matter of high policy. And I would argue what has become considered a matter of non-justiciable high policy has shifted over the past 30 years, and that's been a shift that has come with intention behind it. So if finding that land rights predated colonisation isn't a matter of high policy, I don't know what is. So I think there's been a shift, right? And what I wonder is what has caused that shift, and it's actually pretty clear and not particularly hidden, including through books like that of Tanya Joseph called The Campaign Against the Courts, including in a book I put out with Monash in the National Interest Series, that really looks at the efforts of groups like the Sir Samuel Griffith Society, which was established immediately after Mabo and Wick to deal with the risk that decision was posing to their to mining and pastoral interests and to land interests. And that campaign has been very, very effective, and I would say has not kept the court in a judicial lane, it has narrowed what the judicial lane means. And I think you see that in a whole range of areas, not just climate. You see it in protest rights decisions, you see it in warrants for raids decisions. So thinking about Annika Smethurst, effectively the AFP were told, no, you shouldn't have done that, but it was because of this technical issue with your warrant, and AFP then put out a press release saying, it was actually just a technical warrant issue, it wasn't really a problem for our democracy. ABC losing its case for that it should have had protection against the AFP raiding it over its war crimes reporting. And, even Professor Adrienne Stone, who's extraordinarily eminent constitutional lawyer, really, she plays things straight down the line on what the law says. She even in comments at the 30-year anniversary of the ACTV decision, the implied freedom of political communication decision, which is what is at play in these protest rights and journalistic freedom cases, said that the constitutional approach to decision-making in Australia has become extremely brittle, leaving it open to problems. And she said, if you had told me 30 years ago that Roe v. Wade would have been undone, I wouldn't have believed you, and I see the same pathway being possible here for implied freedom of political communication. At the same time, Simon Stewart, who was the final appointment under Christian Porter in the former government, has consistently, in decisions related to the implied freedom, called into question 30 years of precedent and said that he doesn't think it actually exists. There is an atmosphere that has narrowed the judicial lane, and we have to call it out, because if we don't, the judiciary itself could lose its own legitimacy. And I have one just final point to say on this. There was an excellent speech given in 2017 by one of the founders and judges of the South African Constitutional Court, Edwin Cameron, in 2017 at the High Court, where he essentially said, if you guys keep doing law the way you're doing it, you're going to undermine your own legitimacy and see yourselves in the position that the South African courts that allowed apartheid found themselves in, which was needing to take them down and start again. That's a big, big thing for someone like that to say. And my real hope, and I think climate change is a perfect example of this, is that we get to a place in Australia where we can enable our courts and our judges to hold their democratic role fully. We do not have courts to settle divorces and for criminalising people. We have courts to hold up the rule of law, and we've got to make space for them to do that, because they can't defend themselves in the public arena. That's our job. We've got to do that.
Stephen, I wonder if you have any reflections on that, on the sort of role of lawyers in pushing back the sort of narrowing of the judiciary's functions, how academics engage in that space too.
I think the choices that lawyers make in this space are really fascinating. There's a wonderful book by Nathaniel Frank called Awakening, which is the story of lawyers and the fight for equal marriage in the US. There's nothing to do with climate change. But what the book shows you, a very careful sort of empirical investigation, is lawyers sort of fighting with each other. They all wanted to be the ones to bring the case that eventually got to the Supreme Court. It also shows you how complex decisions were made about forum and jurisdiction and claimant. This couple is too ugly for the press. This couple is too open, and their sex lives won't let us get to where we want to be. And so I've always kind of wanted to kind of get into that with climate litigation and climate litigants and climate lawyers. There's a lovely phrase that Kim Bua and Joanna Setzer have about climate litigation and its ability to fail with benefits, connected to what Isabelle was just saying. Judges have an interesting job, don't they? Maybe that's all I can say as Dean of a law faculty, but there is something about lawyers and judges recognising, which they do every day, their special place in relation to the rule of law, the administration of justice. And that then plays in with decisions about the sorts of cases lawyers bring. There was the Client Earth case against Shell in the UK under the Companies Act. Every company lawyer in the UK said, this will never win. They just cannot win. And then the case did not win. The question for me then is that a stepping stone? And in the future it will kind of be referred to, some of the comments in the case will be referred to. But the judge in that case reflected quite seriously on whether the lawyers had brought the case in good faith. Was this a good faith piece of litigation, or was it a waste of the court's time? But how do we set that against our knowledge that certain cases, certain issues need this case and that case, this jurisdiction, that type of claim? You look globally at climate litigation, you think about the UK, think about France and other places, you know that judicial review and Paris Agreement cases tend to fail. They almost tend to fail. Does that mean lawyers should stop pursuing them? Or does that mean you just have to wait for the one case that gets through? What does it mean when cases lead to bad precedent? How harmful is that? And again, all I'm wanting, in a very academic way, sadly, is to open up these questions, not to give any answers, that's not my job, but simply to open up the debate and to gently push the lawyers to say, are you competing with each other? How strategic are you with your strategic litigation?
Thank you. Sister Brigid, I want to zoom out a bit from the lawyers and talk about your time sort of advocating in the community for various issues. What have you learned from your time doing that in terms of how to push causes into the public arena effectively?
I think my first response is that even though issues seem to be really different, with a whole lot of different reasons for looking for change, there's also a lot of similarities between the big areas of contention, I suppose, in our society And often the answers, I don't know the answers either, but the answers lie in the culture of a country, the dominant culture, rather than, at first sight at any rate, just in that specific arena. So things like how much can we generate a belief in our country about the common good rather than individualism? What sort of approaches do we take to nationalism, where borders begin to be very much keeping out those who haven't got as much as we have so that they won't take what we've got? Or that we're better than the people on the other side of the border in another country or whatever, rather than we're talking about human beings here, and also beyond that we're talking about a globe that's either going, a planet that's either going to survive or not. So what are the commonalities that we in a democratic society think we believe in, and when it comes to the test, what do we actually do in the face of many of these big issues? And I think in order to go down what I think, at any rate, probably all of you think is the right way, we need good dialogue, we need good leadership, we need to move from can we get more and more and more for us as a country and more for us as individuals, to what can we do? What can we do to move forward as a total society? Things like, do we debate at all or bring up much for consideration? Things like, enough is enough for all of us? Or is it a better world because we keep striving to get more and more for those who already have a lot at the expense of less and less for those who don't? I suppose I'm going beyond what, but it certainly strikes me that Australia on the whole has, I think, decent people. People I meet at any rate, when I meet them face to face, I think most of them are decent. And that if we had good leadership and good debate and good dialogue, we would continue maybe to refine a bit more where we are. And then certain things would be taken for granted, so that, when something comes up and it's definitely going to be at the expense of a certain group of people, there would be a light bulb sort of for most people that says, hey, let's not go down that path. These particular people are going to be disadvantaged, hurt. And then we'd start self-correcting. I might stop there.
Yeah, thank you. Stephen, I wonder what roles law schools play in developing the common good, in allowing, in training the next generation of lawyers to think about these issues in much more expansive terms.
I think we're probably already pretty much perfect on... No, we're not. Sorry, that was a joke. The deans get to have lunch twice a year with the Vice-Chancellor, and we are generally asked one question, which is, what's keeping you up at night? And when we had the one in February and March, I said, I'm struggling to understand the role of universities as social institutions, and what our obligations are in relation to our moral courage. When should we be speaking up, on what issues, in what ways, how do we use our expertise in the public interest? And that translates down into what my job is and what the job of other deans of law schools, what they have to do. Law schools are generally very conservative, and what I mean by that is we like path dependency. So we teach contract and tort and crime, and we teach them in blocks, we do it in certain sorts of ways. We don't really have to do that. Even when we have relatively strict rules on accreditation, we don't have to teach something called tort. So I had a conversation with a colleague who's a climate litigation expert, and I was like, gosh, your research is phenomenal. I love what you do. And you also teach tours. I'm guessing that you bring this phenomenal expertise and, showcase that to our students and taught. Oh, you don't? Why is that? Well, can I? Yes. And I think part of my job, part of the job of a law dean, is to give permission, to say, go and give it a go. Like whether it's climate change, whatever else it might be, bring that into the way in which we teach. There's a bit of a debate we're having at Monash, and I'm on one side, which is about whether we are there to create a safe environment for our students or another type of environment. And I'm pushing back on safety. And it's not that I don't want our students to be respected, to be protected from certain forms of harm, but I think our job is to offer places of challenge, respectful challenge, to say to them, these are the complexities of the world. These are the issues that are going on at the moment. I'm not going to hide away from them, and I'm not going to harm you, but I'm going to kind of bring these to the forefront and have the conversation. Now, that's very easy for me to do like this. The hard work, my colleagues in the room will make done over the next 12 months, and thank you to all of you.
Isabelle, on the theme of challenging things, what impact do you think a Human Rights Act might have made to the Australian climate case? Or what impact do you think a Human Rights Act might make more generally in this space?
So this case didn't have a human rights frame on it because we don't have a Human Rights Act. So we could have had a different case. Different communities could have brought it. One of the reasons that the uncles had a strong case, a legally strong case despite the outcome, is because of something called the Torres Strait Treaty. And that Torres Strait Treaty, the Australian government signed, saying decades ago, over 50 years ago, or about 50 years ago, saying that it would protect the land, environment, culture of the Torres Strait and took on responsibility for doing that. So that's where the duty was, partly what the duty was argued to be hinged on, and that wasn't a part of the case that was kind of fatal. And also, we just got to wait and see what happens with an appeal. But this case could have come in a different way, much sooner if we'd had a Human Rights Act. A whole bunch of stuff that's happening right now wouldn't be happening if we had a Human Rights Act. There would be a whole bunch more opportunity. I feel at the same time that it's really important that we have this conversation about the judicial lane and the judicial role, because there is a risk that even with a Human Rights Act, with a self-censoring judicial, self-limiting judicial role, we've got to be judicial lane, just to make it really clear. I'm not suggesting anything otherwise, but we really need to create a space where the court could comfortably make decisions in line with the Human Rights Act, and I don't actually think that that's culturally true at the moment. And I don't even think it's true of the culture necessarily in parts of the bar in the way that people consider the way that the law should operate. So that's one part of the human rights piece. The thing that is also important about the human rights piece is looking up to the International Court of Justice decision, which came down the night before last, which is a phenomenal decision, and it makes it very clear that Australia could be sued by other states for reparations for its failures on climate change. And there's just something I want to say about that, just with the next couple of weeks, what's happening in Canberra, something that I really think is an important piece for people to be across. The government is about to announce its climate pollution reduction target for 2035. That's called a Nationally Determined Contribution, NDC. So if you see NDC, that's what that means. It's climate pollution reduction target. And the ICJ is really clear. You have to hit 1.5 degrees of warming as your maximum. That is your legal obligation, not 2 degrees, not these other kind of numbers. And those numbers sound small, but you're talking about billions of people and the differences between them. But what's really clear from the ICJ is you have to hit 0 by 2035 at a minimum. What we're hearing is that the government is looking at somewhere more in kind of the 60s, a 60% reduction, not a 100% reduction. That will have consequences. Legally, that will have consequences. It will mean the Australian government and the Australian country and us as people will be liable for reparations to other countries. So it's something that we really need to be paying attention to. And I urge you, if you have any opportunity to talk about this publicly, to really focus attention on that net zero by 2035 is actually what the law says and it's what the science says. The Academy of Sciences says that's what we need. The Climate Council says it's what we need. It's what was accepted by the court in Uncle Pabai's and Uncle Paul's case, it was accepted by the court in the ICJ-AO. So that's something, a really important piece of context that I would love for us to be paying attention to as a community who cares about human rights. And, you know, you talk to the communities in the Torres Strait, like this is the difference between them losing their homelands or not. You know, we've already got kids on these islands. They are walking to school in knee-deep water. These are Australian schools, Australian kids going to Australian schools in knee-deep water at king tides. It is an absolutely horrifying situation. And the difference in these numbers, it sounds sort of technical, but the difference is, do they have homelands or not? And as Auntie Rose, senior Saibai elder, said after the decision, she spoke directly and she said to Chris Bowen, who she knows and has known for a long time because she's been a long time climate advocate, she said, you come and sit here and tell these kids that they're going to be moving off their homelands in 30 years. You have that conversation with them. They're really powerful advocates on the ground, and in climate litigation, often it's the First Nations people in Australia who are on the front lines because they are the people who are being affected first.
I do want to move to audience questions in a moment, so please be thinking about your questions and have them ready. Sister Brigid, I wonder what sort of strategies you might suggest for somebody who wants to get involved in more sort of community activism, who's trying to support, say, people on the front line of climate change, to advocate for, you know, more ambitious action by the government to address emissions. What would you suggest from your experience? You've spoken already about a sort of personal connection.
Over and beyond personal, yeah. I mean, that is the first stage, I suppose, is the personal. It's hard to advocate for everyone else and the whole country if we're not doing anything personally. I remember seeing a video at one stage where cleverly the designer of the program showed all of these coffee cups, and there were so many coffee cups that got bigger and bigger and bigger, you know, and showed that we were drowning just about in coffee cups. And I think it was at the beginning of my sort of thinking, what should I be doing, because I'm not doing much. So I decided then and there not to buy another coffee cup. And it seems a terribly small thing to do, but it's the one thing that I can claim that I probably haven't done since that day. So the personal is important. But I think our whole thinking about overconsumption everywhere and just bringing things up for debate, I think I said that before, but I do think that what we talk about and what gets shown on our televisions and so on, that education part of where we move is terribly important. We've had some success more in the, not in the asylum, in the area of climate justice, but more for asylum seekers, because that's where I work day by day. And, you know, MPs don't tend to want to know anything about asylum seekers because they're a bit of a problem. They don't know what to do with them. And if they don't get talked about and they kind of go away, that's the best thing that they can hope for. I'm not speaking about every member of parliament, but a fair number. So just plaguing them, just writing letters to them, turning up at their offices, urging other people to go in and say, look, I don't know much about this, but I met some asylum seekers and look, their situation's dire. Do you really know how they're living and the level of insecurity they've got and how unfair it all is and so on? Just go and talk to your local member and they'll get sick of you, particularly if you get your friends in, they'll bring it up somewhere. So I think that's the same with every major issue. Education, I have said, the consciousness that we can build about each of these major issues, in particular climate. I mean, we don't have to know a lot to know that if we don't do something, the future is terrible. You know, that, and most people can understand something about CO2 emissions and so on, even if they're not scientists and so on. And I think that the whole thing about relationships, that one thing affects another, affects another, affects another. I think justice on the whole is about right relationships. And so we've got to get relationships right, not just in one area, but in lots of others, yeah.
Thank you. I wonder if anyone in the audience might have some questions.
Hi, I'm Carly Goldstone from the Australian Human Rights Commission, and I was wondering what impact will the ICJ case have on domestic cases here and possibly an effect on future legislative reform?
So in terms of litigation, obviously it's not a binding judgment. I think we've got to figure out how it's going to affect things. I think part of it is, I always think of that line in The Castle, it's Mabo, it's the vibe. And the vibe matters, I think, more than we like to admit. One of the things, it was interesting hearing you talk about the marriage equality decision in the Supreme Court in the US. Another really great book is by David Cole, who was and maybe still the legal director of the ACLU, called Engines of Liberty. And in that he talks about, and the American legal context is obviously different, but he talks about really interestingly how basically the same legal argument was prosecuted for a while and not, the legal argument didn't really change over the decades. The zeitgeist changed of what the court felt was sort of possible and in alignment with its remit. And so I think that sort of that diffuse impact of the ICJ. I understand that opinions are being sought locally from barristers across the country at the moment about the potential implications for next steps for particularly resourcing projects, so that sort of level of decision making. I'm hopeful that it will have an influence to put pressure on the Australian government to be more in line with what is required by science, because that is now very definitively what is required by the ICJ. And as I say, what that would mean, which I don't think anyone is expecting, but that would be a net zero emissions reduction target by 2035 announced in a couple of weeks. I don't think that's what we're going to get, but I think that, and I'm hopeful that it will help put pressure on, that's the direction that we need to go. I think the Pacific Island states are also going to be using it as leverage, because, well, they've said that they are going to be, and that is obvious why they need to do that as well, because they now have actually got a litigation pathway directly against the Australian government for their failures.
A few years ago, I was in charge of an environmental law and governance master's program where we'd have drinks for all these students. And Rocky Hill had just come out, and I'd read all, 27 million pages of it. And I was talking to the students, and I said, this case has come out in Australia and New South Wales, and it goes on and on and on and on and on. Gosh, and kind of the judge is just going on, and Brian Preston, what's he doing? And I walk away, and my colleague says, oh, did you meet Brian's daughter? And I said, who's Brian's daughter? Rebecca Preston, you were talking to about that case. That was slightly embarrassing. But my point is, in that case, you think that Justice Preston is going in one direction. There's a lot about the Paris Agreement and international obligations, and there's a lot of kind of reflection on those commitments, international commitments, and then the case is decided on a technicality over here, on amenity value, I think. Even when things like this advisory opinion are not binding, there is that level of judicial discretion to speak to other things. And Justice Preston, what I like about his extrajudicial writing, talks about the judicial environmental literacy that is needed in the judiciary, and I'm kind of curious about the extent to which this opinion will be referenced, not where it's needed to be referenced, but where judges have agency to make that reference.
I completely agree, and I feel the same way about the factual findings in the Pub-A versus the Commonwealth case. And the point around judicial understanding, even, senior barrister level understanding of the climate science, I have been quite surprised by the gap, in the literacy gap there. I had at one point thought, maybe we just need to send everyone Joelle Gurgis's Australian climate scientists book so that we can just have a good starting point, because I think what people perceive as possible in the law radically shifts, especially in the common law, radically shifts when they actually understand the detail of the science. And so that is actually a big piece of the puzzle.
I think there's a question there in the middle to the back in the red blazer. No, it's fine.
I'm Natasha Yacoub from the Caldor Centre for Refugee Law at the at UNSW. I thought the presenters all tied in really nicely with each other, and my question also is to all of you, I guess, and that's about the question of transnational judicial dialogue. So I just finished with a couple of people in this room, actually, a book on strategic litigation in refugee cases, and we were looking at, or for the chapter that I was working on gender, was the impact of decisions in other national jurisdictions on courts in Australia. So that was under Kirby, like the case that I was looking at. So it was a particular set of circumstances with the judiciary, of course, as you mentioned, but the impact of decisions in other places was key, I think, to the other judges coming along with that, and also tied in well with advocacy, so with people understanding the issues because of what was going on internationally as well. So it was really more of a transnational discussion or dialogue between judges in a way. And I wonder to what extent where, if strategic litigation is not necessarily strategic within a domestic context because of competition, to what extent transnational judicial dialogue might be taking place already, or might be an answer to that, or useful in this context, useless.
I think it's really important, and it's definitely, I think actually even like international private arbitration is really interesting and important on climate stuff, on climate litigation particularly. And because Australia, I would say, is slower generally to evolve from that common law point of view, like looking at causation, for example, or complex causation. I had a conversation with a very senior Australian judge, recently-ish retired, who said to me that their view on causation, complex causation in relation to climate change, had shifted since being at an international conference of jurists, where they started to connect the dots between the other ways of thinking to their own. So to me, it's a really important part of the puzzle, because people, obviously, you listen to your peers, like, who am I to tell a judge like what they should be thinking, right? But if their peers are really grappling with these new problems that the law hasn't confronted, and it's going to have to confront it in lots of ways, talking about forever chemicals, PFAS, microplastics, there's a whole bunch of complex causation stuff that is coming through the pipeline, not just on climate, and that conversation is really essential. And one of the things I'm trying to figure out is how to make more of it happen. So yeah, completely agree.
It's not, but it should be.
This might not be around the same, answering that same point, but one that it's prompted me to think about is in the area of refugees, asylum seekers, people being displaced and moving, how much we should be learning from each other across different countries. And there's a group at the moment working on, almost finished, fairly significant paper, well, we think it is, on the regularisation of visas here in Australia. And as part of doing that, we looked at lots of the academics in particular in the group did this, but the rest of us sort of hung around and listened to what they were coming up with. What different people, different countries have done in terms of both law, practice, policies, regulations and so on. And, learning from what in my mind they got away with in terms of good laws, good policies, and then the results of that, and trying to see what's applicable from one country to another. I'm not sure whether we do enough of that. I'm not in the legal field enough, or I'm not in it at all. But it seemed to me from that exercise that we could do a lot more in terms of comparative studies in the area that I know something about, and trying to get the best of what's happening everywhere, and trying to get some agreement, I suppose, on what is the best and then doing it in different places. But that would be a big move forward.
I think there's a question in the middle, or just there, in the dark grey blazer. Yeah.
Yes, thank you for your time today. It's been really interesting. Tanya Murphy from the Australian Human Rights Commission. This is probably one for you, Isabelle, but happy for any of the panel to take it.
Could you just speak up slightly if you don't mind?
Sorry, I was really interested in the moving towards the zero-based emissions and the fact that we seem to be lagging behind and not making that commitment to do so. Where do you see the state-based regulators and federal regulators having a part in this, obviously to try and meet this target when the government may not be doing so?
Thank you. There's a massively important role, and that is in regulating generally companies. And part of the challenge is to make sure that we've got precedents that makes it as easy as possible for regulators to do their job. It's really hard for regulators to take really high risk litigation against major corporations. It's really expensive, it doesn't look good. And so for me, it's about thinking through and encouraging litigation where it can, that can set precedents that regulators can then follow. And so we've seen that recently. ASIC and ACCC both, I think ASIC has launched proceedings and the ACCC has made some statements which effectively would have been very difficult for them to do if it wasn't for some of the work and the heavy lifting that's being done by civil society. So, for example, the Parents for Climate Action litigation against Energy Australia around offsets, and that being bullshit, really, just to call a spade a spade. And, they didn't win the precedent, but they won the settlement that effectively gave them what they needed. And so, to me, we need to create pathways for regulators to do their job. It would also be nice if regulators were able to take the settings that enabled them to push the law themselves, but that's just not where we're at right now. But yeah, definitely there's a focus on the corporations who are producing these fossil fuels and lying to us in the process, because that is what's happening. It sounds maybe a bit dramatic to use that language, but if you at its simplest terms, that's what's going on.
The only other thing I'd add is we had a great event at Monash 2 weeks ago on COP and the potential for the Conference of the Parties under the UNFCCC to come to Australia and the Pacific for COP31. And one of my former PhD students, Montse Madariaga, she's Chilean, and she looked in her PhD at the COP that was meant to take place in Chile but then moved to Spain because of social unrest. And the whole point of her PhD was COP as a moment of potential, a moment of hope, a moment of action. And so as we're thinking about, what's happening here, what might be said in terms of goals and targets, if it is decided that COP comes here, a lens, a spotlight will be shone on Australia, and if it's in Adelaide, on South Australia, and what are we doing? And what you see in lots of other countries where COP has taken place, not everywhere, it's not universal, is politicians and state-based actors and mayors of cities and local authorities and others stepping up their game because there is just much greater international attention. So, we might, I'm generally pessimistic, but we might see something there as well.
Hello, I'm Charlie. I think everyone knows who I am now. I was wondering about the judicial, narrowing of that lane. It seems like it's something that is done by the legislative branch kind of on purpose. If we look at things like your mandatory minimums and then all the discourse that came around the NZYQ and how dare the court do that when it was clearly just following the law. How does the judiciary push back? And I think we're seeing an erosion in the countries like the US where they haven't been able to push back, and it's very dramatic.
It's hard. They can't. Their job is to not make public comment on these sorts of things. Justice Kirby has a bit since his retirement from the High Court, but it's really tricky, and that's why I really feel like there is a really important role for civil society. It's it's non-profit organisations, it's media entities that are pushing it the other agenda, and so it kind of falls back on civil society and communities to push back in the other direction. But to your point about legislative moves to make it more difficult to reach the judiciary, that's absolutely true. We're seeing that in Queensland, the Northern Territory. We saw it recently around Tasmanian fisheries at the federal level. Attempts to basically follow the well-worn path of the migration system and make it really difficult to get review from the judiciary. So that's a pattern that is definitely emerging around the country, and I think it's something that we've got to. That's a very specific example of something that we've got to push back on and say, like, actually, sorry, it's unacceptable for government to just say, nah, we can't have a judge look at these things just because we don't want them to. And then in terms of that, you know, that much broader cultural push, you know, you have a major decision come out of the High Court, something like Unipingu or Love and Tom's. Where you hear about it? You hear about it in Janet Albrist's column in The Australian. You hear about it on the front page for weeks. Where don't you hear about it? Anywhere else. And that has an impact in terms of the kind of the colour of the water that the fish are swimming in, I suppose.
Yeah, I hope this is sensible in response. I mean, we need to keep looking for alternatives to legal decisions, don't we? And in the Sharma case, the climate case where I was the litigation guardian, I mean, the young people were dismayed by the fact that even though the first decision by Justice Bromberg, I think, said that, yes, the minister did have a duty of care to young people in terms of opening up new coal mines, the decision then was, but the law couldn't stop, or the law wasn't going to stand in the way of her making a decision about continuing or enlarging the coal mine that was in existence and making it, you know, more productive and so on, or simply enlarging it. But the thing that did come out of that, even though there was a moment of sort of very big sadness for the young people in particular, but I thought it was a moral victory because the litigation part of it did not say in the first instance that there was no duty of care to young people, nor did they question any of the data that was put forward. So you have to sort of think, well, okay, they've accepted all of the science and no one's questioned that. And at least initially, yes, the minister has some duty to next generations. So where can we move from there? It won't happen right now, but having had that case, was that helpful in terms of moving from there to the next reality of testing out this stuff? And I think that has happened because even though I'm not directly involved in much of the climate justice stuff, I keep looking at it with great interest. And I see many of the cases now that are being brought forward bring up duty of care in some shape, make or form. Yeah.
I just completely agree, and I think that's the one thing, on the one hand, while I'm talking about reclaiming the judicial lane, you know, at a Mabo implied freedom of political communication level, I'm not saying let's go crazy. It also is part of a broader system, as you say, and, you know, Anjali Sharma's work in particular after that decision has been phenomenal. Her advocacy for a duty of care bill is amazing. Her, you know, really deep connections she's built in Parliament are amazing. But also the work, you know, she's done with other communities who are pushing for these fights, including she travelled with Uncle Pabai and Uncle Paul to Vanuatu on Greenpeace's Rainbow Warrior. They spent a month together on that boat, getting to know each other, planning for what comes next. There are so many. I love hearing you speak about the interconnectedness and the relationships, because that's where everything really emerges from. And I think in law you can get really hung up on like who won, who lost, and that kind of piece, but actually the reality is it's much more interactive and emergent than that, and there's so much that comes from those relationships and the connections between people like Anjali and the uncles, and more to come with more litigation that's happening. You know, look at Raylene Cooper, she's fighting at the moment in WA to try and protect a million-year-old 50,000-year-old artworks against a gas expansion that's going to destroy them. You know, you look at Gomeroi people, you know, you look up in the territory, like there are people all over the country who are doing these things and finding connection and solidarity and meaning in there as well, which is a big part of it.
Hi. Oh. Is this on? Yeah. Hi, Rowena Cantley-Smith. For my colleagues from Monash will remember that I did energy and climate change law for many years before I went to New South Wales. I just want to thank you all. Wonderful presentation. But also wondered if we could maybe have a look at, if I understand correctly, the judicial lane issue. You're predominantly talking about federal courts. And in my experience, and most recently yesterday, the New South Wales Court of Appeal handed down a fantastic decision in which the Upper Hunter Healthy Environment community groups attempt to overturn the largest coal expansion in Australia has been approved. So that's a fantastic win for a community group against a government and the planning decision to arguably make a terrible, terrible contribution to our national emissions, particularly through Scope 3 emissions. But I wonder if part of the problem here with climate change is that what I've seen over the last 2 decades is that energy law in particular is a major source of emissions, Australia and worldwide. There's no constitutional competency for that. So it's state-based laws with some national laws that the states allow the Commonwealth to be involved. So how do we deal with this in climate litigation when some of the states are being really progressive in climate litigation, like this New South Wales case? But getting back to your bigger question of climate litigation and human rights, at the same time, these very same states are passing really restrictive protest laws, criminalising what is essentially basic access to justice and public participation. We see Civic Monitor ranking now Australia as narrow. So we see all these things happening. So I'm just wondering if you could maybe talk a little bit, if it's possible, about the role of climate defenders and what their role is in climate litigation and human rights, seeing how successful the New South Wales group were yesterday. Thank you.
Yes, and big shout out to the new organisation Climate Defenders Network, who are a phenomenal new group that I'm so happy exists, who are really focused on looking after and supporting protesters, particularly climate protesters, in the face of really extreme anti-protest legislation across the country. We also had reports over Christmas that Australia is the most criminalising state on protest of like countries. That's kind of a big deal. So they are definitely part of it, and I want to make sure that I don't mean to suggest that this narrowing of the judicial lane means that the judicial system isn't doing its job. I think it's doing a terrific job. I think that's a really good example, and you win some cases, you lose some. This is not about like, oh, we lost, so the judicial, listen on that. That is a kind of a broader point, talking about like kind of a federal system and how that works. And there are good cases happening, and massive shout out as well to Elaine Johnson and Johnson Legal, who won that fabulous case yesterday. They're also representing Raylene Cooper in her claim in WA. But protest defence is a really big part of this, but you also hit on something else which is an important part of it, which is this litigation should not need to happen. We have a government and governments that are meant to legislate for the public good. It is possible for them to do so. We could have a Human Rights Act, we could have fair and appropriate protest laws, we could have fair and appropriate climate laws. We don't. And so, you know, the framing of this conversation, and obviously my particular lens is litigation, but there are obviously other tools available to us as well, which include, of course, legislative reform.
I'll ask the question. I'm really interested in, do we always have to wait for things to happen that have gone wrong, and then there's a court case about it, and then there's a precedent set, sort of. How much of a role is there, and where does it come from, to actually get good frameworks for making decisions at a government level and so on, without the court cases having to happen?
It's a very simple question. No, that's a very big question. I think it depends on appetite, doesn't it? It depends on majority, it depends on people and their preferences, it depends on where you are in election cycles, it depends on social movements and social mores. And I had a discussion yesterday with Eleanor Campbell about her sort of career and 10 years working as a ministerial advisor, and my ignorance, I said, and why did you leave? And she said, the government changed. And so, you know, kind of what I was doing, the kind of the possibilities that were there for the previous 10 years just went away. And I think that happens a lot. And that's one of the problems where we have this multi-generational issue of climate change, where, you know, you see, you know, over very short periods of time, governments changing, priorities changing, withdrawal from international agreements, and so on. I want to come back to the protest question to make 2 points. One is, I've been writing about the lawyers who prosecute those climate activists and what that means, and kind of what I think of those lawyers, which is a fair bit. And the other thing that I'm interested in, actually, let me explain that, because that sounds very flippant. There comes a point, I think, so every lawyer has the ability to have a view on the content of the law. So you might say, this is what the law is, and I have a strong sense of duty to not challenge the law and to help operationalize it. But you can, in parallel, also have a view about the validity, the quality, the accuracy, the correctness of the law. And I think we sometimes forget that. The other really interesting thing at home, and I'm not sure, sorry, my old home, not what happens here, is last year there was a GP who was convicted for breaching an injunction in relation to climate protesting, and the medical regulator suspended her practice for 5 months because she'd been found guilty of that offence. At the same time, the regulator of solicitors, the Solicitors Regulation Authority, has a guidance document which says, for climate protests, we think these are acts of conscience and we will not take action even if you're found guilty. How fascinating that the medical regulator goes down one path and the regulator of solicitors does something quite different. You know, I find that kind of fascinating because, again, it's coming back to a question from earlier about different actors and groups. You know, how are regulators of doctors and lawyers, etc., responding to these existential questions, and where people feel an obligation to speak up, to do something, to protest?
Thank you. I think there's much more we could say about this issue. In some ways, I feel like we've only scratched the surface of the depths and the breadth of the issue. But I hate to stand in the way of a cup of tea for you. So please join me in thanking our panellists.